Hello everyone, nice to be with you tonight or today wherever you are. I'm Dean Hutchison, I'm the Director of Legal here at Circle, and I wanted to thank you for taking the time to take part in this webinar. We're going to be talking today both to intended parents and surrogates that have joined us about the U.S. insurance system, just a very basic background on it. I'm going to speak first. Second to speak is going to be Natalie Canellis. Natalie, many of you may know, we're on the phone. Natalie is one of the attorneys here, and she is the legal manager of the legal team and works a lot with the insurance appeals. And then our president and founder, also an attorney here, John Weltman, will speak last on what we've been seeing over the last year and a half, as well as with the most recent election on how this may impact insurance and what we've been doing proactively to approach this. So just some very basic housekeeping before we begin. During this webinar, you're going to be listening in by phone or computer. I'm sure you're all doing that now. You are on mute, but you will be able to ask questions as we go along. If you look on the right side of your screen, there is a question box, and you can type questions in. We'll probably hold off on the questions until the end, but you can ask the questions as we're going if something pops into your mind, and then we'll go through those questions, and each of us will answer which ones most relevant to us. Also, we are recording this webinar, so if you have to leave or you think you missed something, we will email it to everyone who's taking part, so you have it moving forward. So again, the main topics we're going to go over today, just a very basic background on the U.S. insurance system, as just looking at the list of who's here. Many of you are from overseas and aren't used to the system we have. What we do at Circle to review insurance for intended parents and surrogates. I'm going to talk about the issues that we've seen intended parents and surrogates face from an insurance perspective. Natalie will go into examples of matters we've handled and assisted intended parents and surrogates with, both with their own plans as well as private purchase plans. And then we're going to talk again about what we've seen over the last year, how things have changed, what the election means, and the new things we are planning on doing to assist intended parents and to protect against these issues. So first, just very basic background on U.S. insurance. Majority of people working in U.S. and surrogacy and just American citizens use some type of private insurance. We do have a public system as well, but it's only for certain income brackets, etc. So most, when you're doing a U.S. surrogacy, most of the surrogates are going to have some type of private insurance in place, and the intended parents who are from the United States are also going to have their own private insurance for certain coverage. In the United States, insurance is a for-profit industry, so there's obviously a little bit of a bias from the insurance company sense is that they're trying to make money. So even though they're selling plans that are supposed to protect you and cover things, they do have a bottom line to it. The insurance contracts or policies that the surrogates have or the intended parents are drafted by the insurance companies. So they can, and depending on different state regulations and laws, they can really put any type of exclusion or things in their policies to try and avoid paying in certain cases. Just last week there was an article in the LA Times, Los Angeles Times here in the United States about my last comment, which is insurance companies tend to try and avoid paying out claims unless it's something completely obvious they're responsible for. There is usually again a bias towards not paying. And this article showed that over the last couple of years they've done statistical research, and insurance companies were denying even obvious claims with the mindset that most people will just pay and not even fight it because they're looking at a giant insurance company and they're just a normal citizen and they don't want to put up the fight. That is very, what Natalie will talk about later, but one of the very big benefits of Circle is as part of your relationship with us, we will fight those appeals that we deem to be wrong. And when there's a denial, we're going to at no extra cost fight the insurance appeal with the internal insurance process. Just some very basic common insurance terminology for those of you not using our system all the time. we have what's called premiums. That is the payment that insured person makes on a monthly basis to have insurance coverage. So that is just the fee to have insurance. It has no impact on coverage amounts, et cetera. It's just what you pay to make sure insurance is in place. The other big term is deductibles. So that's the amount of money the insured must pay each year to cover eligible medical expenses before the insurance actually kicks in to cover above and beyond. And I'll go through a little example after this so you can see how it works. But so there's always going to be a monthly amount of payment and then a certain amount of pay or a certain cost you owe before the insurance fully kicks in and covers everything. There's also what's called a co-insurance, and that is usually based on a percentage, and you'll see it in these policies, and it's what we're looking for when we're reviewing it, on what percentage the insurance company will pay on the cost above that deductible. And again, I'll go through it in my little example, but usually it's somewhere 70, 80, 90% in most plans that the insurance company will cover the first 70% of the medical expense above and beyond your deductible. And then there is what's called the out-of-pocket maximum. And then this is the most money that an insured will pay during a year for coverage. Depending on the plans, it always includes a deductible, usually includes co-pays and co-insurance, but you have to look specifically at the insured policy to see what's covered under the out-of-pocket maximum. So once you get beyond that amount, the insurance company will pay all expenses for the remainder of that calendar year. So that's why it's, when we're reviewing insurance and we're looking at things, we're bringing all of these factors into play to see what the surrogate's insurance covers, etc. The only things I didn't put here are what's called co-pays. That is just what a person pays when they go to the doctor each time or when they have a prescription. And most of our insurance has a certain set amount that you pay, like $10 to $25 for appointments with the doctor, and then depending on the type of medication needed or prescription, you pay a certain amount for each prescription as well. So those are kind of the major terms that are used in U.S. insurance. So this is just a breakdown, basic example of how insurance works. So what I did here is let's just say the person has a $5,000 deductible and a 20% co-insurance payment and an out-of-pocket maximum in $6,000. So in this case, we say a delivery had $12,000 in expenses. So in that example, the insured would be responsible for the first $5,000. So the first $5,000 of all medical expenses is paid. Then once that deductible is paid, the insured is then responsible for 20% of the co-insurance until you reach the out-of-pocket maximum. So in this case, it's a $12,000 bill, a $5,000 deductible, there's $7,000 remaining. 80% of that would be paid by the insurance company to the hospital or the provider. You would be, or the insured would be responsible for that 20% up to the total amount of $6,000, which is the out-of-pocket maximum. So in this case, you'd be responsible for an additional $1,000, so you'd be paying $6,000. Now, anything above and beyond that $6,000, since you met it, if there were any complications after, et cetera, would all be picked up by the insurance because you've reached the out-of-pocket maximum for the year. The one thing that you will see too in U.S. insurance is there are sometimes procedures that come up during a pregnancy that may not be covered at all. For example, your surrogate may have a plan that allows for 3 or 4, let's say, sonograms or scans during the pregnancy, and for some reason the doctor may order a 5th or 6th. So certain things like that, if it's uncovered, you pay the cost. Usually we can assist in getting a reduction, but you'll pay the cost, and then that doesn't go towards the out-of-pocket maximum or the deductible because it is an uncovered cost. So what we do at Circle, initially when all of our surrogates, when they're in the application process, they send us their insurance policy, and we're reviewing it for these things I talked about as well as others. So our legal department reviews it. It's a 2-person review. One does an initial review, marks up the policy, fills out a chart, and then another attorney reviews a secondary review to just make sure everything is set. And we're looking at, number one, making sure there is maternity coverage, so that's coverage for the pregnancy and delivery. Currently, that is mandated under the Affordable Care Act or Obamacare, which many of you have probably heard about in the past. And as John will talk later on what we're seeing, there is a potential for Obamacare and this Affordable Care Act to go away. And in that, the mandate for maternity coverage may go away with it. These are things that haven't happened yet, so we're not sure, but that could cause to less people to have this insurance. So we're looking, number one, to make sure there's maternity coverage. We're looking at both individual and family deductibles in the plan. So just so you know that sometimes people have a private health insurance that's their own policy. So a surrogate may have her own policy that's separate from her family's, and she would be under individual deductible. So that's just for her. Sometimes she's on a family plan, so her whole family is part of her plan, and she'd be responsible for the deductible for the family or family plan when she's going for her appointments. Just in general, that can have some positives. I'll give you from my own life. I have 3 children and a wife. When we go to the doctors, it's all pooled into one deductible. So if you were to have a surrogate who had a family on a family insurance plan, her own family's medical appointments and procedures will be part of that deductible. So you could get very lucky in the sense that when your child is born, that full deductible has already been used, and they're close to the out-of-pocket maximum, and you may have a lower cost. So that's one little positive that can happen on a family. We're also looking at the individual and family out-of-pocket maximums, as we just discussed how those relate to each other. We're also looking at in-network versus out-of-network coverage, and what that means is the way insurance works is everybody's plan has a certain network that has providers and hospitals they can go to that has one type of coverage, and then usually there's a separate percentage of coverage if they have to go to an out-of-network hospital. The reason why we want to know this is sometimes if there's an emergency at birth or if something happens and the surrogate has to go to a separate hospital, we'll know what the difference in coverage will be if she needs to see a specialist or needs to have emergency care somewhere. We're also looking to see if there's dependent care. In some cases, intended parents rely on that insurance to cover the children born. What dependent care is coverage for any child or children of the surrogate. It also can, and what Natalie will talk about later, in coordination of benefits. We have seen on occasion an issue where a surrogate gives birth to a child for domestic clients, and because the hospital is just used to billing a certain way, in a sense, sending all the bills to the insurance company, and if that surrogate's insurance does have dependent care, they may send the bills automatically to her insurance company, even though the intended parents are responsible for them. So we just want to see what the care is in case we have to deal with that in the future. But the main thing we are looking for as well in these policies is exclusions. And what exclusions are is insurance companies have the right, as I said earlier, to write those contracts and to put specific prohibitions on coverage into their policies. So they can write, we'll cover X, Y, and Z, but we won't cover A, B, and C. So what we're looking for is to make sure there's nothing in that policy that specifically excludes the insured or the surrogate to act as a surrogate and still have maternity coverage for the surrogacy. So what I put here is a couple examples. So what we see in very good language, something we'd approve is something like this here that says, exclude services or supplies provided to a person not covered under the contract in connection with a surrogacy arrangement. So because that was written to say excludes provided to a person not covered, it's specifically saying if you act as a surrogate, we're going to cover the cost, but if we won't cover the cost if you use a surrogate to cover her costs in a sense. So because language like that shows that A, they know about surrogacy, and they're excluding one type while not excluding you acting as one. And then just an example of bad language is exclude surrogate services, including services and expenses related to conception, pregnancy, delivery, or postpartum care in connection with a surrogate agreement. So this is such a catch-all, end-all that we wouldn't approve this policy to use for surrogacy because they've specifically excluded that woman or that insured acting as a surrogate and any care provided in relation to that surrogate agreement. Natalie may touch on this on her topic, but those exclusions that are put in, sometimes they're very ambiguous or they're put into locations in the contract that still make it seem that the insured has coverage. And the way our insurance legal system works here is that because the insurance company is drafting it and the person who gets that policy has no kind of right to negotiate and add their own provisions in, that any ambiguity in that contract is construed against the insurance company because they drafted it. So again, Natalie will speak to it later, but when there's something that is ambiguous or just put in the wrong place, we've been very successful in fighting to say, you do have coverage as a surrogate because they wrote the policy wrong, and it's very ambiguous, and people could see it either way. So I'm just going to give a couple examples of what we do as part of our the insurance kind of management and what we do as part of your fee with Circle and your experience, and how we get involved throughout the process. And then Natalie will come on after me to just give specific examples of what we face and how to kind of avoid it. So number one way we get involved a lot is sometimes very early on in the pregnancies is doctors and providers and hospitals refusing to submit claims because they know it's a surrogacy. So sometimes they say the agency or the lawyers think they're doctors, but a lot of times doctors think they're lawyers and don't even review the contract or don't review the surrogate's insurance and simply try and refuse to submit a claim because they think it's wrong and they shouldn't do it because it's surrogacy. So we'll have surrogates call us and we'll get in touch with either the employer or the provider directly or the insurance company just to make sure everyone knows it's fine and they can submit the claims. Sometimes during the pregnancy or after the pregnancy, the insurance company will ask for information on the surrogacy. We get involved in just assisting because that's obviously the intended parents and the surrogates sometimes feel nervous about these things. We're happy to assist in any way we can and be the attorney and the agency involved. Natalie will speak more to this, but the insurance companies can deny claims. And obviously, as I said earlier, we will fight those appeals and we'll fight those denials with the insurance company through their appeal process. Sometimes when a surrogate has more than one insurance in play, there will be billing issues that Natalie will discuss between which company should be paying first or second, et cetera. So again, that's another place we get involved. And then we also have intended parents, domestic, who are trying to add the children to their policy, have issues with coverage for that child if it's born in a different state. We do not request intended parents insurance policies. We do when it's an international person who's asking for us, has a global policy and wants to use that insurance here in the U.S. We usually ask for it so we can review it and make sure it works. But any intended parent who's on this call who's domestic as well, we're happy to review the plans just to make sure there's no issues and you should have full coverage no matter where the child is born. So with that, I'm going to turn it over to Natalie. As I said, you can ask questions throughout this process. If you can, so anything I just talked about has spurred a question, feel free to start loading up the question box and we'll get to them at the end. But for now, I'll turn it over to Natalie, who will speak on specific examples of these issues we faced.
Thank you, Dean, and hello to everyone. As Dean mentioned, there's quite a few different instances with insurance and billing that the legal team gets involved and Circle gets involved. And the one I'm going to start off with is the coordination of benefits issues. And this happens when a person, usually the carrier or the surrogate, has more than one insurance policy. Now, if we'd been talking 3 years ago, we wouldn't have even mentioned this because it never came up as an issue. 2 years ago, it never came up as an issue. 1 year ago, we had one isolated case. We wouldn't have talked about it. But now it's coming up, and it's absolutely connected to what Dean said and what the Los Angeles Times reported, that insurance companies currently are just looking for any way possible to avoid pain. And they have attacked the coordination of benefits clauses with a vengeance. And so now we are assessing exactly how to deal with it, and we're strategizing in a number of ways. Coordination of benefits can be good, right? I mean, you think you have two policies that ought to be better than just one. I know that would be my instinct. And the very first time Circle to my knowledge, dealt with a coordination of benefits issue. It definitely did not, it benefited the intended parents, benefited the child, it benefited the surrogate. We didn't get involved at all. In that case, there was intended parents that had a baby that had some very serious issues upon birth and was in the NICU for many, many weeks, if not months. It was about 3 years ago, so I don't remember exactly the details. Now, the carrier, the surrogate, did add the baby to her policy as a dependent, and that insurance was covering. But we thought because we could, we understood that the bills were going to be extremely large, we thought it might be a good idea for the baby to have an individual plan as well. And so the intended parents and the surrogate together signed up the baby for an individual plan. And what happened after that, was very interesting because after the baby was discharged, I got a call from the hospital, and they actually conferenced me, and they had a few people from the hospital, and they explained to me that the negotiated rate that the hospital had with the insurance policy for the individual plan was much less favorable than the negotiated rate they had with the surrogate's plan. And so they explained to me that because the individual plan was primary, the hospital got paid several $100,000 less than the hospital would have been paid if the surrogate's plan had been primary. And after about 10 or 15 minutes of them explaining this to me, they told me that they wished that that the individual plan had not been purchased. And I said, do you need me to do anything? Are you looking for anything from me? And they said, no, we just want you to know that. So that was just such an interesting tidbit that they did that all on their own, the hospital, the two insurance companies, and again, their main concern was for me to know that they suffered from the choice of purchasing that individual plan. Now, if insurance plans always just work like that and we never had to get involved and the intended parents weren't, detoured in any way and the surrogate wasn't hurt, we would have no issue at all having 2, 3, 4 policies. But what's happened lately, and some of you may have experienced it, is that now when a surrogate has 2 policies, the billing is getting very messed up, even if we use our best efforts to make sure it doesn't. And because of hospital billing being the way it is and insurance sort of business practices not necessarily being as efficient as they can be, it can take a long time to sort things out. So what happens here, the coordination benefits can come up with, as we mentioned very often, if we review the insurance policy and there's an exclusion and we say we cannot use this for a surrogacy journey, then very often intended parents will purchase an Affordable Care Act plan for the surrogate, and the surrogate will use that Affordable Care Act plan for her maternity. Now, what we have found, because this was the isolated instance we had about a year ago, is that even though there's a clear exclusion and everybody agrees that the personal plan will not cover the surrogacy pregnancy, the ACA plan still requires that all the bills be submitted to the individual plan first, rejected because of the surrogacy, and then sent with the claim and the explanation of benefits from the first insurance and individual plan to the ACA plan. Then and only then will the ACA plan cover it. Now that is, it makes no logical sense because, you could we can all agree the first policy doesn't even cover it, so why are we doing that? But at one point, I actually got the legal departments involved of both insurance companies and the hospital, and both they agreed that that's just the way it had to be, and they were very sorry. So you have to jump through all of those hurdles, and in other words, you need 3 people, one insurance company, the second insurance company, and the medical providers to all do everything right so that there won't be a mess up. And that just doesn't happen. We're seeing now in the last few months, we're getting some rescissions, some denials of of claims because it didn't go to the first policy first, even though there was an exclusion. It's almost an exercise in ridiculousness because the first policy doesn't cover. But that's what they are doing now, I suppose, just in the hopes that the ACA plan won't, that people will get worn out and that they won't have to cover. The other way that the coordination of benefits issue has become important, though, is that in the past, if a surrogate came to us and they said, hey, I just don't want to use my policy, we would say, well, we understand, that's fine. And, as soon as a private insurance policy would be purchased for the carrier. Prior to ACA policies, there were still some private policies that could be purchased. After the ACA policy, it made sense to do it through the Affordable Care Act. But another policy would be purchased for the carrier. She would present that for her maternity expenses and use her own policy for her other expenses. And that worked for years without an issue. Now, again, because they're just vigorously enforcing the coordination of benefits procedures, and I believe that the Affordable Care Act has changed the coordination of benefits in many of their policies, because to know which one is primary and which one is secondary, you have to review the language in both policies. But now for that carrier, the surrogate who says, I simply don't want to use my own policy, we really can't do that anymore if her own policy is going to be considered primary and the Affordable Care Act is going to be considered secondary. Because under this new enthusiasm of enforcing these clauses, her personal policy is going to be, the claims are going to be processed through her personal policy, regardless of what we try to do or what she tries to do, if it is the primary policy. So we have found that out. So just for a variety of reasons, it's become, the coordination of benefits issue has become very messy, and the initial list of that Dean presented of the ways we might get involved, all of those almost get encompassed in the coordination of benefits issues. Because what happens is once the billing gets messed up, then the hospital goes on automatic protocol and starts sending out billing statements, even though they know full well that it's going to get paid. It's just a matter of processing it correctly. And the insurance companies can mess up once and twice and three times. So before you know it, it's 6 months later and it's still not straightened out. It's very frustrating for everybody. And so what we are doing here in dealing with it is, first of all, each time it happens, we go through the steps that we need to go through with our billing people, and Art Risk is helping us since they're the insurance experts, and just giving instructions to the medical provider what needs to be done. If necessary, again, sometimes legal, or I can get involved to sort of make sure that they're moving along, because what happens is they just get into this state of stagnation. We believe the reason it never happened before is, like I said, I don't know exactly what, and when I look at the policies, the coordination, I think the ACA policies are changing their provisions to make it more likely that they are the secondary policy. And as a result, so for example, in the past, if a surrogate was a dependent on her husband's plan, for example, and the Affordable Care Act plan was primary, which was her individual plan, then the Affordable Care Act plan would be considered primary, and her individual plan would be considered secondary because she was a dependent. Now, many of the Affordable Care Act plans for coordination benefits will say that they are secondary to any group policy. So that makes it secondary to her whether she's a dependent or not. So it's something that's not a benefit to anybody. And what we're planning to do in the future, what we're recommending in the future, and John will talk about it more, is the Lloyd's plan, to use that, because with the Lloyd's plan, or the universal plan, it's tailored directly to surrogacy. There are no coordination of benefits issues. You're not going to have that. So for the carrier who doesn't want to use her own insurance, that's fine. She's not going to have any coordination of benefits policies problem. She's not going to be forced to use her own policy. if she doesn't want to. And for those carriers who have the exclusion, instead of buying the ACA plan, the Lloyd's plan is becoming much more, well, the ACA plan is becoming more expensive, and plus with all the complications of the coordination of benefits, what can happen there is that the Lloyd's plan is just looking all that much more attractive. And what we can do for currently, because I know people are going through it, and for those that, if any of you are out there that I'm talking to directly, obviously we're dealing on a case-by-case basis, but for any carrier who, or surrogate who right now is going to the doctor and has two plans, the best advice there is to give the doctors both insurance cards. And I have spoken to a few medical providers on this issue, and they too are finding that it's a new issue. And previously, for example, in the isolated instance I'm thinking of about a year ago, the medical provider sent some bills to one insurance policy, some bills to another insurance policy, same surrogate. They were very willy-nilly about it. They did not know it was a big deal. I mean, now the medical providers are understanding it's a big deal because it affects them too. So they are learning how, and they now know what to do when they have two insurance cards. So the best thing you can do is provide them both cards so that and just tell them your concerns, and then let them deal with it. The other way this can come up, the final way before we talk about appeals, is that a surrogacy journey can go on for obviously more than a year, and I understand more than anybody that even though this is what I do now, so insurance is interesting to me right now, historically I had very little interest in insurance. So I can understand any surrogate who, say, starts the journey and doesn't have insurance, so then she gets her ACA plan purchased for her, and somewhere along the way during the year or two, the next year, perhaps she starts being covered by her husband's plan, or perhaps her job starts offering her insurance, and she doesn't think to tell us. I mean, that's happened to us a few times. And so the coordination benefits can also be complicated in that scenario when there's insurance policies that we don't know about. So again, something that we can do to make sure that we're analyzing everything correctly is for all the surrogates to make sure they tell us whenever they have new insurance. The second thing I'm going to talk about is appeals, and that is something that I think that we are most familiar with, and when somebody hears the thought about a denial or rescission, that's the type of thing that I know for a fact it makes intended parents and it makes surrogates nervous and very uncomfortable, and I understand that. But as Dean mentioned, because we do the thorough review of the insurance policies, and because we have a long history of understanding insurance law, we feel very confident when we approve an insurance policy for maternity coverage or for dependent coverage. And for that reason, we do expect to win the appeals. And one reason we expect to win the appeals is because all we really need to know is what is in that insurance policy, right? I mean, they can't change the words, regardless of, sometimes a surrogate will tell me, oh, I feel I said the wrong thing, or they asked me this and I didn't say that. And I always say, it doesn't matter what you said. It doesn't matter what they said. All it matters is what the insurance policy says. And those words, I mean, there's 100 years, 200 years of case law mandating, just exactly that the insurance company needs to say what they're going to cover and what they're going to exclude. If they don't do that, the inference is that coverage is going to be there. They know perfectly well how to deny things if they want to. They know perfectly well how to exclude surrogacy for an insured carrier, or they know how they can explicitly say we're not going to cover a child born to a gestational carrier. That's their total right, and they can do that. If they don't do that, we have very good success saying, this, then you have to cover us. That's another thing just to shout out to, and I was just mentioning for carriers to make sure they tell us whenever they have a change in insurance policy, because your surrogacy journey is based on the insurance that you provide us when you're matched. And sometimes, and I know it happens, an employer might change the policy and not even really give fair notice. I mean, we've seen that happen. Oftentimes you get more choices, you're going to change, etc. It's just really important to keep us updated and to let us know, because again, a surrogacy journey can last more than a year, and an insurance policy can change, and it's vital that we have the most up-to-date insurance policy that you have. And Circle has gotten more proactive in regularly checking to make sure we have that. But what happens typically then is, for maternity coverage, let's say they reject it for maternity coverage. We used to see that all the time because surrogacy was rather new, right? So surrogacy, an insurance company might just think, I don't know what this is, so I'm going to deny it. Now they're more comfortable with it, and as Dean mentioned, right now they specifically mention surrogacy in some exclusions, so they absolutely know what it is. And what we're seeing now is that many denials are simply mistakes. And so even though for maternity, even denial can sound scary, when you look at it, it's simply because a representative at the insurance company saw the word surrogacy in the exclusion, concluded that therefore, these maternity expenses are excluded. And those kinds of mistakes are very easily corrected, and we often correct those, even before it gets even to a denial. Like Dean had said, sometimes in a doctor's office or hospital will say, oh, I don't think this is covered, and then we will review it and talk to the insurance company and confirm that it is. Dependent coverage is also based on the language in the insurance policy. And again, it's in those cases where we use the dependent coverage, the surrogate typically is still on the birth certificate, so technically she is still the legal mother. The policy will talk about a natural child. There's very good legal precedent as to that the natural child is reasonably interpreted to mean the child born to a gestational carrier. And we have been very successful defending the dependent coverage during those times that we use it. I'm going to give you just a couple examples of recent appeals that we had. In one case, the insurance company denied coverage for maternity, saying, and the language in that policy did say that the policy excluded costs for maternity care if the surrogate is not a member. So that's that good language Dean was talking about. So there's an example of the insurance company simply seeing the word surrogacy and denying it, and obviously we're going to win that appeal. The second one we won recently had to do with the out-of-network denial. That was one Dean also mentioned. That's an issue that's coming up a lot. And it's not an issue, to the extent that something's out-of-network, that's fine. But what has happened quite frequently now is that the doctor will be in-network. He won't tell you that the hospital is out-of-network. The only hospital that he delivers at is this hospital, so you assume it's in-network. And then you get the bill for $8,000 because it's out-of-network. Well, we were successful there. We recently also won an Affordable Care Act, it was an Affordable Care Act policy for a surrogate who did add the twins as her dependents. This was kind of a big test for us because obviously previously we've been using a private insurance, and we had every reason to believe that the Affordable Care Act would act just like any other insurance company. We found out that in fact that was true. The Affordable Care Act policy covered the maternity but said the dependents, they rescinded payments for the babies. They were saying because she was a gestational carrier, they were not proper dependents. And we appealed that, and we were successful there, and they agreed with us that the babies were dependents, and they covered all of the medical bills there. And there are numerous examples of when we've been successful. I would say, unfortunately, we can never guarantee success. It's always on a case-by-case basis. As I mentioned with the one intended parents with a child that we knew the bills were going to be very high, then we might recommend that there also be the individual plans just in case. If a case where the babies are perfectly healthy and the bills are going to be, say for twins, $8,000, then we're not going to recommend necessarily any kind of backup plan in case the insurance doesn't cover, because it's a cost-benefit analysis. To get additional insurance, that costs money as well. The billing issues I'm going to talk about now, just a few examples, because if you're sitting out there, you probably have encountered them already. And I know we have NES now dealing with some of the bills, and Circle still deals with some of the bills. And there's room that we can improve for sure. But the thing we have found is, say, we can give you an example of a situation where everything is done absolutely right on all of our parts. The surrogate sends us the bills right away. The bills are paid right away. The insurance covers it. That's not an issue. And still the surrogate will get like a collection notice. I mean, that, unfortunately, that's just the reality. If you look in the news, you will see numerous articles about medical billing practices and medical collection billing practices. And there is legislation pending in a number of states to clean up their acts. And it's not that the hospital, it's not that the hospital, obviously they're good people, right? But the ones that do the billing, they're an arm branch of the hospital or the medical providers, and they don't necessarily do things right. They don't necessarily use good judgment. They don't necessarily communicate well with the rest of the hospital. So we often get billing, collection notices, those things that are not warranted. Now, if they are, obviously we deal with them, and even if they're not, we deal with them. But that's one issue that comes up, that we'll get, the surrogate will get a collection notice, and then she'll bring it to us. Another issue is, as Dean mentioned, sometimes the hospital will mistakenly add the babies to the bill for the surrogate, and either bill the surrogate directly for the baby's bills, or bill the insurance company, her insurance company, for the baby's bills when they were supposed to bill the intended parents directly, or the intended parents insurance company. And again, on a case-by-case basis, that could either work fine, like everything could be just sorted out, like or sometimes the hospital might think they sent a bill. But this happened recently where the surrogate suddenly got a bill for the baby when the intended parents had given the insurance information like 3 years ago. So now she's getting a bill that's 3 years old, and what could have been sorted out quite easily a month after delivery is much harder to straighten out 3 years after delivery. And that's not because the surrogate was delayed. She's told us as soon as she found out. It's because for whatever happened internally at the hospital, they first billed it wrong, and then they sent out to the wrong person. Just any number of situations like that can happen where we need to get involved to sort it out. One of the things that for the surrogates, I know it's important to them. Obviously, people get tired of getting bills in the mail. I know that. Also, if they call it a collection notice, that's stressful. I understand that as well. If it's occasionally, if it ends up on your credit report, that's not acceptable, and there's no question about that. So one way we get involved, and one way that we're trying to minimize, to the best we can, that would ever happen, is for surrogates to help them with the billing issues, and for surrogates to know that they shouldn't be shy about telling us they need help. And I know surrogates doing their best to give us the information as soon as possible, and not to be afraid to say, hey, I haven't heard from you, because sometimes we can follow up immediately. It can take time to deal with the hospitals, and it's always going to be okay to follow up with us as often as possible. That last issue, or let me just talk about Another thing we've seen, actually, let's talk about the delayed billing. The one thing I know is frustrating to intended parents, and again, we're seeing this more and more. We used to say that we're going to close out the account 6 months after birth. Now, 6 months after birth, sometimes we haven't even gotten the hospital bill yet. And so that's the problems with delayed bills that are coming up. We're still trying to totally understand that. It's partly hospital processing or insurance processing. It's partly hospitals. And it's kind of ironic that they're so quick to send out the collection notices, but they take their own sweet time when sending out the bills. But that's just a reality that we have to deal with. And the last thing is the insurance company stalling on decisions. And that's what we've seen. You know, we told you we can deal with an appeal very easily. That has sort of regimented timelines. But what happens, we've seen just a flurry of cases recently are like 3 or 4 situations where the insurance company will say, well, you didn't add the babies, so it's like, so you don't really have anything to appeal, so therefore we don't have to pay any attention to you. That's what we're seeing right now. I mean, at times, like if for example, the carrier doesn't add the babies, the surrogate doesn't add the babies because there's automatic coverage under the policy, or because there's a 96, or because maternity, the charge for newborn is under the maternity care, you wouldn't add the babies. You wouldn't worry about whether they were dependents. And in that case, the insurance company recently, just a couple of issues recently, it's just very hard for them to even comprehend or to understand that they need to even deal with us. I mean, they almost stall. I mean, years ago we had an insurance company stall for years. Right now we're having a stalling lasting several months, and we're strategizing on how to deal with it. But again, the ironic thing there is that if an insurance company stalls or doesn't answer properly or doesn't respond properly, even though they might have won the initial issue, what they're doing there is setting up kind of a bad faith claim. So we've been successful in that too. If an insurance company won't respond to us, if they won't respond to us, if they won't articulate, a legal reason for their denial, then we can fall back on the argument that they have a statutory and a statutory duty and a contractual duty of good faith, and by ignoring us, they're not acting in good faith. So again, even though it can be very frustrating when they stall, ultimately it can turn into a claim that will finally get coverage just a little bit slower than it was before. So at any rate, I'm going to turn over to John now, who's going to tell us some of the ways we're going to alleviate some of the insurance issues we've had.
Hi everybody, John Weltman here. I'm the president of Circle and been a practicing lawyer for 33 years, and a lot of it in dealing with insurance companies. I've represented insurance companies in the past, and I have been fighting with insurance companies for this company for the past 21 years. You might listen to this and say to yourself, God, that has to be the worst thing in the entire world, an insurance company. Their bottom line is basically you're paying them premiums, and their bottom line is made by finding ways not to pay out, delaying paying out, hoping you never chase them. And that is the United States. We care more here about money than we do about human life. If an exclusion exists in a contract that says you can't get a replacement heart and you need a replacement heart, if you don't have the money, you die. You can go to court trying to force it to happen, and you still die. And that is really, really hard to listen to. All we have of coverage is for the very poor. They don't make great surrogates, I'm afraid, and for the very elderly, who certainly don't make great surrogates. So we're in this situation, and you could come to the conclusion saying that's a disaster. But in fact, what Circle has done that's different than every other agency is that we have 8 lawyers here. And most of the time of those lawyers is spent dealing with these insurance issues. So no matter what the insurance companies come up with, our fees include following every line down so that you have the coverage that you anticipated in the first place. And that includes dealing with these coordination of benefits issues. It includes dealing with these delay issues. It includes dealing with even the appeals where they wrongly deny a claim. And as a result, on the course of the last 21 years, Circle has never had a situation arise where anything exceeded the out-of-pocket maximum on those deductibles, co-pays, and co-insurances. And that is a remarkable thing. And so as a result, and you'll hear a little later in my presentation, when I went to London, we asked Lloyd's to back us so that if we were dealing with a surrogate who had our own insurance or a surrogate who had Obamacare, that if our appeals ran out and for the first time we lost, they would cover. And they said yes. And they said not for any other agency because we actually had 50% fewer complications and a 100% success rate that no one else did. So I think that's a very important thing. So despite all these headaches you may see, because that's how the insurance companies in this country work, we're going to be there to help you. Now, there is definitely been more problems since the Affordable Care Act came on scene. Don't forget that we've been around for 21 years, and for the first 18 years, there was no Affordable Care Act for either surrogates or children, and we dealt with either surrogates having their own policies or the Lloyd's of London plan. But since Obamacare has come along, we have seen lots of changes, and you have to realize this is a mathematical challenge issue. It's a capitalism issue. The issue is if you have no pre-existing condition exclusion and you allow a surrogate to buy a policy because she doesn't have other insurance at the last minute and pay $200 to you, and you have to pay out on a $12,000 or a $15,000 bill on $200, you're going to find other ways to make your money. That's going to be all kinds of things that we've seen. We've seen a drastic increase in premiums and deductibles since Obamacare began. We've seen shrinking networks of doctors that are acceptable because they want to pay them so little. We've seen a shrinking number of available plans. Literally, there's nothing in Obamacare that forces the insurance companies to continue to offer it. The idea ultimately was to have a single federal insurance company that oversaw this, funded by tax dollars. Aha, the much hated socialized medicine of America. It never happened. And so as a result, you're getting fewer and fewer insurance companies wanting to offer this and no obligation for them to have to. And literally states disappearing where you could get Obamacare. And then this issue that had also arisen where they cut off the year December 31st. So even if you bought Obamacare, in some time where the year would not have ended in December, if your child or your surrogate was covered during December and January, you were going to have to pay those deductibles twice. So these were problems we were seeing anyway with Obamacare. Now, I went to London in September, which was before there was much thought that Donald Trump was going to be president of the United States. And so we were dealing with the fact that Obamacare was problematic. But there was still the possibility that Trump would come into office. And he has talked from the very beginning about, and even now, about repealing Obamacare, about potentially not enforcing individual mandates, about repealing the maternity. He hasn't talked specifically about the maternity issue, but there is this potential that the maternity mandate would be repealed. And so that would mean that surrogates who either didn't have insurance or had insurance but there was an exclusion for surrogacy could not get Obamacare. So we wanted the return of the Lloyd's of London plan that we had used previously, but we wanted it at a better rate. Just so you know, there is a brokerage, Universal Family Insurance, in which I am an investor, which has for some time been offering insurance through Lloyd's of London for complications for surrogates, complications for donor, accidental death and essentially like life insurance for surrogates, although I've been told not to call it that, just because of the way they fashion it. But in any event, same thing. And also maternity care and backup policies. So when I met with them, I wanted to find a less expensive alternative. I wanted to basically be able to promise everybody that their surrogate's insurance would cover everything except the out-of-pocket maximum. And that meant that if we were doing because it was a surrogate's insurance we were using or an Obamacare plan, if we were doing those appeals and we got to the very end and never having lost before, for a very small sum of money, could we get something that said Lloyd's of London would back us up? They would effectively guarantee up to $500,000, up to $1 million, whatever it took to get coverage to make sure the surrogate was covered? And the answer was, for Circle, yes. And the next question was, what about we have about 70% of our surrogates who have insurance that we can use after we read these 100-page policies and make a determination about whether it's usable or not and feel confident that we're going to win. There's still 30% who don't, who have an exclusion, who don't have a policy. What if Obamacare goes away? Right now, I wouldn't use an Obamacare plan after January 31st because it's just an uncertainty until we know for certain that the maternity care policies or the child care policies are going to continue. I wouldn't use it. So what can we use as an alternative? Can we get a discount for the Lloyd's policies, which are specifically designed to cover surrogate maternity so that the surrogates don't need to worry, so that the intended parents don't need to worry? And the answer was yes, we could obtain both of those things. So as I indicated, the 70% of surrogates who have coverage, the 70% of surrogates who have coverage have extra that gets paid to them for having that coverage. And we are there so that if there's any issue, as Natalie has described, we're there to deal with it literally all the way through the insurance appeals process. Now, the backup plan that Lloyd's has offered for only $1,500 basically says that they will cover up to $500,000, and I don't think we've ever had a surrogate have that level of expenses, but you can pay a little bit more and get $1 million of coverage if you prefer. That is a secondary or backup policy. This now says, God forbid, you get into one of these situations and for the very first time lose. The surrogate and the intended parents will be covered. And don't forget, surrogate coverage is an intended parent responsibility. Ultimately, if she loses, so do you. And so do the intended parents. And so as a result, this will make sure nobody loses. You have a guarantee. For the 30% of surrogates who either have no coverage or coverage with an exclusion for surrogacy, we now can offer significantly reduced in price Lloyd's policy if Obamacare continues to be uncertain. And this policy runs about $10,500, and it is a policy which basically covers specifically surrogate maternity. And we have gotten them to agree to improve the number of ultrasounds so that it is in keeping with what you would anticipate. And the maximum deductible that can come out is $13,500. It doesn't mean you're going to spend $24,000 in this policy. It may be less than that. That is the most you can pay for a singleton. It is more if you decide to have twins because that is a riskier venture for the deductible. But effectively what this policy does is guarantee coverage for surrogates and intended parents. That was very problematic under Obamacare. And I think with these two offerings, and I'm not setting aside the possibility in the future if Obamacare stays around for maternity or child care that we won't use it. But for these two options, you have 100% security that you're going to get no more than the deductibles, and that you're going to have a lot less problems with these coordination of benefits issues that have been going on for some time. So as time goes on, Circle has always tried to remain ahead of things. We're keeping an eye on not just what Trump says, but what the Congress declares and decides and he signs. We will always err on the side of conservatism. Part of the reason Lloyd's offered this to us is they indicated that we had a 50% lower complication rate than any other agency they were dealing with. And that was very significant in offering both the reduction and the guarantee. We will continue to be there for you. And that means no matter what of these things happen, don't assume we've done something wrong. This is the craziness of insurance in America. But I believe that you will be safest with us because we consider ourselves responsible for all of this and ultimately to give you a product which you can count on.
All right, so I'm going to open up the questions. If you have any that you haven't asked, as I said earlier, you can type them into the question box, and I'm going to start going through and see what we have. Okay, there's one question. If the intended parent has a pre-birth order that records his name on the child's birth certificate, is the child still considered a dependent for insurance purposes? So this depends on a couple of things. Number one, you can get a pre-birth order that just establishes paternity and keeps the surrogate on, and it also depends on the surrogate's plan. So usually, if the plan is to use the surrogate's insurance for dependent coverage, you're going to be working in what's called a post-birth state that presumes that birth mother is the mother, and her rights won't be terminated till after birth along the state's regulations and laws. And then you would, because she's on the initial birth certificate as well as the presumed mother, the insurance would work. However, in some states, you can still just get a pre-birth paternity action, which is simply declaring the biological father to be the father. And it keeps the surrogate as a mother, and her rights can't be terminated until after birth as well. So similarly, she would work. So it just depends. If, though, you get a pre-birth determination that says you are the sole parent and you are the only parent, the intended parent, then you most likely couldn't use the surrogate's insurance. If there's some type of automatic coverage, you could try, but they would have a strong argument to say no.
I think Dean's being too light on this. Our general rule of thumb is no. Try to get the surrogate remaining a legal parent in order to have coverage under her policy.
The next question is, when can an insurance company enforce a lien based on the total medical expenses incurred for the pregnancy? How often does it happen? I'll answer briefly, but let Natalie jump in as well. Usually, you'll know it in advance. We will see it in the insurance contract when we review it, so all the parties will know in advance. There's a certain company out in California and other parts of the country called Kaiser that always has this lien. But as part of their policy, you actually give the surrogacy contract usually before the process even starts, so they see the amount that's there for medical expenses, and then they actually tell you what the lien is in advance. In some states like California have a certain regulation on what they can charge. I don't know, Natalie, if you want to jump in on that as well.
Yeah, the lien that we deal with most of the time is the Kaiser one in California, and they are very easy to deal with. Art Risk and I have talked about Kaiser on a number of occasions because even though it doesn't sound great, it's a lien, it's still, their lien can only be up to what the surrogate is compensated. So they look at her base fee, and sometimes they look at extras, for example, extra for a multiple birth or whatever. But then by statute, they can only collect 1/2 of that, 50%. So typically you're looking at a reasonable number, again, compared to what an Affordable Care Act plan would cost. And I don't know, we've had liens of $8,000. We've had liens of 12,000. But now that with the Lloyd's plan, actually that puts a new twist on it, because when you compare it to, say, the $15,000, then that's pretty close to what the Kaiser lien is. So you definitely would factor that into what you're deciding. There's other states that look like they look like it might be a lien because they want to see the policy ahead of time. I'm thinking of the Walmart policies in the Midwest, but those aren't really liens because all they want to make sure is that the carrier isn't getting paid twice. For example, they don't want her insurance to cover the maternity expenses and then for the intended parents to pay for it. So they don't want to have her to have double coverage.
Can we unmute me? We're on.
We're on.
Okay. The only other thing I would say is that the Kaiser is not a lien for the entirety. So if you had a $100,000 surrogacy, you're not looking at something like that. These end up being along the same lines as the other policies for the most part. They lien a piece of it, not all of it.
Next.
No, that's correct. That's correct. So in the case I've looked at recently, her medical bills are quite high. They were up to, so she must have had, I can't remember the details, but yeah, the lien or what had to be paid was in the $12,000 area. Yeah.
Next question. Do I understand correctly that the backup plan for a fully insured surrogate is $1,500 US? Yes. Are the risks higher for losing a denial process today compared to last year? I don't think they are. The only thing that I don't think we mentioned that I actually don't believe it comes into play until 2018, and this won't impact the success of appeals, but it appears that there will be some new medical coding going on at most hospitals and providers that will specifically inform insurance companies when it's a surrogacy or not. Again, as Natalie and John mentioned, it doesn't matter if they know it's a surrogacy or not, because it's what's in their insurance policy. So there may be potential for more appeals coming up because of that coding language. However, that doesn't impact the success of the appeal because they're still bound by what their insurance policy states.
No, that's right. And in fact, we're trying to get all the details of the new coding. The new coding might actually help because right now, sometimes when the bills are denied, it's because the medical provider wanted to code it under surrogacy, and the only surrogacy coding right now is under IVF, which very well may not be covered by the insurance policy. So right now, sometimes trying to code it, the medical providers trying to explain that it's surrogacy are creating denials, where if we actually have a code for a member maternity expenses acting as a surrogate, it actually may help.
Just so you know, going forward in 2017, and we will issue our new rates this month or next month, we will be mandating that backup plan just because I don't even want one couple in that situation ever. But for those who are already in our process, it's a choice. You can add it if you'd like.
New question, how does the new insurance issues and changes that may occur with the Trump administration apply to those surrogates and intended parents who have already signed contracts and have a pregnancy in process? So this is all looking to the future. Even if tomorrow President Trump was to say, I'm repealing Obamacare and it's gone, it's still, whatever insurances are active currently are active through the end of the calendar year. And I even think even if he was to, or they are to repeal it soon, and again, I'm speaking on my own belief system, but I think it'll still have a 2 to 3 year phase out anyway, mainly because in our system, because you have to get reelected every 2 years in Congress, you don't want things to impact your reelection campaign. So they would like this to happen, any major change to happen after the next election cycle. So it shouldn't impact anyone who's currently pregnant and has insurance through the end of 2017.
But one of the concerns that has been raised, and that Dean did raise in his conversation, was that what happens after December 31st? The policy you're purchasing is good in 2017. And if you have a transfer now and you lose the baby, or you have a transfer anytime after about April when you would probably have the baby by December, will those people be covered? Unclear. And as we get closer to that period of time, there may be a need to supplement insurances with a Lloyd's plan or something of that nature, should that come along and be clear that they're not going to be issuing new policies for next year or honoring old policies to be able to renew them.
I also want to point out too, is there any question that is more private in nature or you'd rather ask it directly? If you're already a parent, an intended parent with us, feel free to reach out to your PC and have them put you in touch with myself, Natalie, and we're happy to answer anything specific after today.
One other thing to say is that there's a law in the United States that nobody's attacking at the moment called COBRA that allows you, if you have insurance, to renew that insurance and you lose your job, to continue that insurance for a period of up to 18 months. So if a surrogate has coverage for herself, then we can, and her husband loses his job or she loses her job and that's no longer there, we can continue it for 18 months. You pay a premium for just that person and it continues. That's great. But there is no COBRA rule regarding Obamacare. And so should the decision be made that they won't continue the policies after December 31st, that would be a problem. So we need to take a look, even at policies we're purchasing now in April, and try to make a decision about what the safest avenue is.
Next question, can the Lloyd's $1,500 plan cover twins, or do you have to get one plan per baby? So these Lloyd's backup plans are only covering the maternity insurance. They're not covering the children. So it's a different question. So it will cover a twin pregnancy. Yes, it just covers the pregnancy. So if you're implanting 2 embryos and you have a private insurance plan for the surrogate, the Lloyd's plan will back up the pregnancy and back up the medical costs associated with it.
I guess I should add that there are Lloyd's plans for children available. What we tend to do here at Circle is, if you're a domestic person, you can purchase a policy that will cover your family, even if you're not yet a family. Whether you're one person or you're 2 people with 2 individual policies, you can convert to a family plan that will then cover your children. If you're international and you have global insurance, that should also cover your family, and we can help you vet that as Dean has described. But for those people who want, especially to have twins, and want to have a surrogate who has that rare policy where the dependent care will cover the children even born to her through surrogacy, and I can explain how that happens. We have a standard match program, and then that has always covered. Just generally, it's really only about 10% of our surrogates who have both the type of insurance that's necessary to cover the children and are able physically and willing to carry twins. And so it tends to be a little longer wait and a little more money, not much. But it is something that we do for our international people.
Next question is, I'm a single female IP hoping to get a pre-birth order. Would the child be covered by my insurance from birth? Easy answer, most likely yes, especially if you're a domestic intended parent and you have U.S. health insurance. You'd still want to review it, and as I said earlier, we're happy to review it for you. The things you want to look out for are things like in and out of network coverage, because most likely your surrogate's going to be in a different state, so it may have different coverage. Whether you have an HMO or PPO, because sometimes HMOs can exclude different states. But for the most part, yes, you should have coverage wherever the child is born. And the majority of them have a 30 to 60-day window to add your dependent, and it relates back to date of birth, so it doesn't have to be immediate. But obviously, the quicker you sign up, the quicker you add a dependent, the better. But again, we're happy to look at the policy.
However, this person maybe talking about something that is domestic. In the case of an international person, it very much depends upon what kind of insurance you have. A lot of people have only in-country insurance. They don't have global insurance. And then you need to find a surrogate who does have that coverage, and it does depend on the language of her policy. So that's part of what we vet here.
Is Art Risk under Lloyd's of London?
The answer to that question is no. Art Risk is a separate company that is a brokerage house that sells insurance that is backed by Lloyd's of London. And so the only way to purchase Lloyd's of London policies is through this combination of Art Risk, which does the selling and explaining, and Universal Family, which does the actual underwriting, vetting whether the surrogate is capable of being under the policy and actually issuing the policy through Lloyd's. So that's how it works.
Is one of the lawyers in your office looking through our insurance before we sign to check exclusions in good language? Yes, for the surrogate, we are reviewing the policies. Usually it's reviewed prior to your match, and you'll get it in your match sheet that, what her insurance is, et cetera. So it's already been reviewed, and then if it changes at any stage during your pregnancy, we're reviewing it. If you mean your own personal policy, whether you're domestic or international and you have some type of policy, we're happy to review it for you. You can get in touch with your PC or your assigned attorney, and we're happy to look through it. But the surrogate's insurance, yes, is always reviewed.
The only concern I have is that the person asking it may have a policy that's not in English, and if that were to be the case, then we would need it either to be in English, or we would prefer to probably have someone from your home country review it for you. We do have lawyers we can recommend to you if you're referring to your own insurance.
Do we need insurance to cover our egg donor? Yes, it's just a simple, what's called complications insurance. It covers any complications that can occur as a result of the IVF process, the medications and the egg retrieval. And it's either as an individual, I believe $300, but if you're buying it in tandem with your surrogate's IVF complications insurance, it's a $500 plan per transfer or cycle.
But this year we are actually issuing a unlimited transfer policy. I can't remember, it's 18 months or something like that, maybe completely unlimited, but it's $800 or $900, something like that. And then even if you change surrogates, if you change donors, even if you have more than one transfer, it continues to cover.
All right, does the $15,000 Lloyd's of London price include the self-insured retention limit of $15,000 to $45,000, which is also the out-of-pocket fee?
So you're talking about the old policies. The old policy, I believe, was $13,500 for the premium with Lloyd's, and $15,000 if you're going to have one child, and $30,000 if you're going to have two. There were lesser expensive premiums, which could get it up to $45,000 and even to $60,000 if you were having twins. But that policy has now been put into one policy, and it is $10,500 for the premium and $13,500 for the highest deductible with one. However, it does go up to the $30,000 if you're having twins. So this is a less expensive policy, almost a 30% reduction. The cost went down from about $28,000 to about $23,000 if for the people at Circle's program.
I just wanted to add one thing when for the intended parents and the who are doing mental calculations. One thing that kind of surprised me when I first focused on it and surprises the intended parents is that the deductibles, the out-of-pocket maximum that Dean talked about early on with the insurance, the regular U.S. insurance, they start anew every calendar year. Now, typically that's January 1st, but depending if it's an employer plan, it could be whatever date the employer chooses. But the point is, if you have a pregnancy that extends over 2 calendar years, you very well may be paying double the deductible. And so, I mean, that's an additional, and it's true with ACA plans, those plans that where the deductibles are increasing, they start fresh on January 1st, 2018. Even if you already spent $6,000 and reached the deductible, you're going to have to start over if the pregnancy expands the year. So it's important to keep that in mind too when you're sort of thinking what makes sense or what your choices are.
Next question. If the primary ACA plan does not cover the obstetrician and hospital chosen by the surrogate, will the Lloyd's of London plan cover it if we were to purchase it as a secondary plan?
I can speak to that.
Yeah. Go ahead, Natalie.
Yeah. I know that Virginia and Art Risk are the people she works with. When they pick out and recommend the affordable care, which plan, they talk to the surrogate and they find out what hospital she wants to deliver at and what doctor she wants. And they make every effort to make sure that the plan they recommend has the doctor and the hospital. I know that can be hard sometimes because sometimes the doctor is in one and the hospital isn't, but I know they absolutely make the effort and to do that. The backup plan for the $1,500, that only comes into play after the pregnancy is complete and if insurance is denied. So it's not really a secondary plan in the way that a secondary plan might be helpful. It comes in if the primary plan denies it. So it would not cover that out-of-pocket, out-of-network person.
However, Natalie, there are still available secondary plans through Lloyd's of London, which you can purchase for lesser sums, like about $4,000 or $5,000, which can become activated if that were to happen. But as Natalie has rightly said, Virginia and we vet things pretty carefully, so barring surprises and somebody changing a hospital or not telling us about something, things are covered under the plans that we choose.
Are you recommending that as intended parents we purchase a Lloyd's of London plan as a secondary plan or as a primary plan?
We're not making any recommendation. It totally depends upon your situation. If you have a surrogate who has a insurance that we've approved, we're recommending that you buy a secondary plan, the $1,500 plan as a backup that will be there if, God forbid, we should lose appeals. If she has no insurance because of an exclusion or just a lack of insurance, we are recommending the primary plan in those instances because right now Obamacare is insecure. I think you can purchase it up till January 31st and I'd be comfortable with that, but once that date goes by and once we get into transfers that are post-April, I will no longer feel comfortable with it, barring a declaration by someone that that part of Obamacare is continuing.
Can we feel completely safe if we choose a plan from Art Risk to our surrogate, no matter which one of their suggestions we choose?
My only comment to you would be up until the issuance of this new plan, there were several choices to choose from as a Lloyd's policy. And I think that with this new plan, it's a better price at a better rate. So I think you're going to find that you can talk to Circle about what policy to buy. And we're jointly working with Art Risk to come up with a single document for you to look at and then just buy. Because I don't think there needs to be choice anymore. We've got a reduction off that is better than any other policy out there.
I mean, the only time a choice would come up is if, as John was saying, prior to a March or April transfer, an ACA plan advised by Art Risk may be still better than one of these Lloyd's plans, assuming you get pregnant on that initial transfer. Question, are you trying to say that if a pregnancy crosses over 2 calendar years, the intended parent would pay the premium twice? But if we purchase a Lloyd's of London plan, we would pay the premium only once, even if the pregnancy crosses over 2 calendar years. So I think the terminology is mixed up. So if you have a non-Lloyd's plan, if you have a private health insurance plan or an ACA purchased health insurance plan, it's the deductible you would pay twice, or potentially the out-of-pocket maximum you would pay twice. You would pay 1 calendar year's worth of premiums and deductibles based how long the pregnancy progressed during that calendar year, and then in the next calendar year, if there's a delivery, you would pay the out-of-pocket maximum and the premium. Whereas with the Lloyd's plan, it's one set cost no matter how the length of the pregnancy over the calendar years. You pay the premium and the deductible associated with the Lloyd's plan, and that's it.
But you should know one thing when it comes to surrogate pregnancies. About 80% of the charge is the delivery. It isn't all the doctor visits that precede it. Those probably cost a couple $1,000s compared to more like $8,000 for the actual delivery. So that's why it doesn't happen often. The 2 calendar years that happen tend to be more about children who, and particularly twins, who are born late in the year and spend more than a month or more than any period of time in the hospital. That's really where this issue applies.
Okay, question, where can we get more information on the Lloyd's coverage and all inclusions and exclusions?
I would say at risk.
Question on newborn coverage. If the baby is born premature, what coverage can we obtain being an international IP?
So at the present time, there is a purchasable policy through Obamacare that covers newborns, and you pay about $200 a month for 3 to 6 months, and then you pay the deductible, which is usually about $3,000, and that's per child. If this goes away, and right now we have no confidence that it will continue, and so therefore I would not wait until the birth of the child, since you can't buy it before the birth of the child, I wouldn't be planning on it. If you're having one child, you can either pay for that child in the hospital, and quite honestly, 99.5% of the time those kids come 37, 38, 39 weeks. They spend 1 or 2 days in the hospital. They cost somewhere between about $700 and about $3,000. It's not expensive. And if you're willing to take on that 0.5% risk that you might be one of the early ones, then I wouldn't worry about it with a singleton. If you are one of those people who doesn't even like a 0.5% risk, or you're having twins where the average cost of twins is $80,000, and I've seen it as low as 2 or 3, and I've seen it as high as 2.3 million, then you don't want to go it alone. If you don't have global insurance, you need to be in our standard match program. Then we will find you a surrogate who from the outset has the kind of insurance that covers children. And I think because this keeps getting asked, let me explain how that works. We look at her policy. We particularly look at the dependent care section of her policy. And usually it comes in one of 3 formats. It says, natural born child for whom you are financially responsible. Well, a surrogate, so start with the beginning. 70% of our surrogates have their own insurance that has no exclusion for surrogacy. Now there are 3 types of dependent coverage. So you get about 21% of each. You get natural born child for whom she is financially responsible. Well, she's not financially responsible for your child, so that's not going to cover you. The next 21%, natural born child who lives with her. Well, child's not going to be living with her, so that's not going to cover. Or natural born child. That generally tends to be a child that comes from her uterus, whether it be vaginally or by C-section, and those are going to cover. So there's 21%. But about half of those women won't do a twin pregnancy, or the doctor won't let them do a twin pregnancy. So you're down to about 10.5% of the women who apply to our program, and we're only accepting 1.8% to begin with. So you're going to take a longer time, almost twice as long to wait, and we're going to ask you for an extra $5,000. But if you want twins or you're risk averse and don't want that 0.5% risk of covering it yourself, that's fine. There are other alternatives though, but they're expensive. The Lloyd's plan for a singleton runs usually somewhere between about $18,000 and $25,000 between the base payment and the deductible, and the cost for twins runs $90,000 to $150,000. Because you have to realize that this is going to base center at $80,000. Lloyd's has got to make some money for the risk that they're taking on. So those things aren't often sold to Circle clients, but there definitely are people buying them, and if money is not an object, certainly you will have coverage. But be careful. The coverage that you get by Lloyd's is usually up to $1 million, and I have seen $6 million babies here, and so that would stop at that number. Whereas right now, at least under Obamacare, there are no caps on women's coverage, so using their policy may be advantageous and waiting the extra time if you want twins.
May have already been answered, but I want to know about the 50% they take from the compensation. Would I pay that from my compensation, or would Circle pay it through the IP? So this is probably a surrogate question asking about the liens that can be placed on the surrogate's insurance. So the way your contract would be set up with your intended parents is that they would be responsible for that lien. So basically what Natalie was saying is, let's say the fee structure in the surrogate agreement says that $15,000 is associated with medical care or whatnot. $7,500 of that $15,000 would be the lien, or the cap on the lien, and the intended parents would owe that money somewhat as like a deductible. Natalie, you can correct me if I'm wrong, but
no, you're right. And it's a very good question, because I do know several surrogates who get you get a letter from Kaiser or their I forget what their whoever I forget who they use to collect the liens, and it looks kind of scary. I mean, it's addressed to you because you're the insurance holder, but you know, the surrogate just forwards it to us, and actually very often ahead of time I can let the Kaiser people know that they should send that to me and not to the surrogate, because the it can be a little intimidating to get a letter that says here's a lien, and you know, nobody likes that word. But if you ever get that letter, you just forward it to us, and yes, it's the intended parent's responsibility. And the only reason your fee is even talked about is because that's what Kaiser uses as a guideline for how much the lien can be.
And Natalie, the surrogate has informed us that the name of the company is Rawlings.
Rawlings, thank you. Yes, I knew it was right on the tip of my. They're actually pretty nice. I mean, they don't seem like it right away, but they're pretty good guys, the ones I've dealt with.
A question: what are the names of the different insurances covering the surrogacy journey required for us as international IPs, and which one of them are at risk to change for us that are hopeful to expect a birth within 2017? So if you already have insurance in place and that you have a delivery expected in 2017, you shouldn't expect any changes. As I said earlier, even if it was there was an executive order tomorrow saying Obamacare is over, it can't take effect till 2018, because those insurance companies have a contract with the insured, so your surrogate or you, so that therefore they can't change that policy that's already in place. I mean, really, even
I think that's part of the Constitution, I think, Dean, impairment of contracts or something like that.
But the problem is that the children. So right now you can buy, actually I'm not even sure you can, you can buy child care only plans because Obamacare still exists. But the question of whether if Obamacare were ended, you know, February 1st, you could purchase those child-only plans anymore, the answer may be no. And so one of the things that we did when Trump became president back in November was to recommend to people wanting twins to either convert to the standard match program, buy a Lloyd's plan, or to change to a single embryo transfer. Assuming you're having a child and you're okay with paying the costs of that, there's nothing that's going to change, or you have coverage to your surrogate. It's not going to change.
If the hospital sends a bill beyond 6 months after the child is born, does the insurance still cover this bill? Yes, so it's usually when we get the bill, it's already gone through insurance. If it hasn't, we would just work with them, make sure it gets submitted through insurance. But it's usually just that when Natalie was talking about bills coming in 6 months later, it's not that it's just a random bill. It's usually already processed through insurance through the hospital. They just take their time in sending out their billings.
People yell at us when we don't return their money within 6 months as we plan to. And it's only ever because we still know there are outstanding bills. And people ask me, how's that possible? Because it doesn't happen in other countries. But I've seen it here a year and a half later. And so I can't tell you what to do. I can only tell you that we won't leave you and we won't take a penny of your money that isn't needed to be spent for a deductible or out-of-pocket maximum.
We have an ACA insurance and this is valid for this year. Do we still have to take Lloyd's of London? Is it recommended by Circle?
No. I mean, as long as you have a baby for this year, in this year, that I don't think you're going to have any problem with the ACA insurance for the surrogate.
I just wanted to add briefly there too is one of the many advantages I think that this might sound unsettling to a lot of intended parents to know that there's uncertainty, but when I talk to people individually, I remind them, like, John's been doing this for over 20 years. There's always been uncertainty, and the fact that we know how to and can learn and adapt and change, and everything's fluid. It always will be. So we can't tell you what's going to happen in January. All we can tell you is that we're going to, when that time comes, we're going to do everything we can to give you the best protection that exists.
By the way, this isn't just about health insurance policies. I've had fights with my own personal home insurance carrier, with my title insurance carrier. It is the job of the insurance company to make it hard for you to get paid out because that's how they make money. And that is the nightmare of our job. And I've been doing it as a lawyer for 32 years, but I've been doing it my whole life because everything's private insurance. And in most other countries, home insurance, title insurance, things like that, those, you still have to fight with the private insurance about it. So the next question, Dean, you want to read regrading?
Regarding the Lloyd's backup policy as a new product, will staff be reviewing existing surrogate agreements and reaching out to those of us who should purchase this policy?
I would say the answer to that is no. This is more about you. Circle has a 21-year history of winning these battles. This is, it's a bunch of things. It's a marketing statement to the world that we are now able to guarantee surrogate insurance. It is not a lot to pay to have security that maybe once we will lose, and we certainly expect more challenges with this coding system, and it's up to you. Once we convert to the 2017 rates, which will either be in February or March, everyone will be mandated, because I don't like to let people take risks. So if you want my advice, buy it. But I will let those who preceded the requirement make their own decision.
I think it was like the last question. It says, I am from Australia. When the child is born, will he or she be covered under the surrogate's policy or no policy at all if something happens? So it depends on which program you're in, whether you're doing singletons or twins. And as John has already kind of mentioned, this was an earlier question, so it may have been answered. But if you're in the standard match program, based on the surrogate's contract, it should be covered under her policy. If you did the fast match, or you're doing a singleton and you weren't relying on it, there are policies you can purchase still during the pregnancy. But as John had mentioned, since the likelihood of complications with a singleton pregnancy is so low that most people don't buy those policies that are available during the pregnancy because they have really high premiums and deductibles. Even an expensive singleton usually doesn't come up to the cost of the actual premiums for those plans. In the very few cases, though, where we've had substantial bills without coverage, we've worked with the intended parents, the surrogate, as well as sometimes the hospitals and the insurance companies in those states, and been able to find plans that have covered and assisted the intended parents in those cases. So it really depends on your situation, but we're always ready to help if something above and beyond is needed at the end.
I think what I've generally experienced here is that for the rare singleton that will come early, if they are slightly early, then the costs are just nothing like they are with twins, because the kids are bigger and they're more developed and it just doesn't tend to be that high. But if it's really, really early, then oftentimes Medicaid will provide us with a policy that will cover children under 2 pounds. And so we've been able to get backup policies for people that cover.
I think that's the last question. As I had mentioned earlier, if you have any specific questions, please reach out to your coordinator. We'll make sure we tell them that there may be questions coming in about insurance that Natalie, myself, or the other attorneys that are working with you can assist with. And also, as I said, we're going to download this presentation so that we can email it to you so you can go back to it in time. But thank you for spending all this time with us. It's greatly appreciated. Thank you, Natalie, for being on, and John. And have a wonderful day or evening where you are.